Today, we're looking at how does a case make it to the Supreme Court. If you're in class, you might have a chart that kind of looks like this. We're going to fill this out. If you're not and you're at home, just grab a blank sheet of paper, preferably like a computer printer paper, like that's totally blank. But if you have no paper, that's all you got. That's all you got. We can make it work. At the top, put how does a case make it to the Supreme Court? And then we're going to go through a step-by-step process how it makes it. And then you have a quiz after. Okay, so first off, there's going to be some violation of federal law or the Constitution. Some violation of federal law or the Constitution. So, there's, someone feels like their free speech has been violated or their freedom of religion has been violated by the government. There's a law that's been passed and you violated it, and therefore you will go to court or to federal court. So that's the kind of the first start. Okay. By the way, anytime pause so you can go ahead and catch up with me. All right. Next, make an arrow and make a new box, and you're going to write this. So then they have a trial. Your trial is always held in a federal district court. A federal district court. I'll talk more about this in a little bit, but there are 94 different federal district court districts, 94 federal districts in the country, and that has over 700 judges in them. So it's very massive around the country. So the trial will be held there. This is a trial. This is a true trial with a judge and a jury, and there's facts and witnesses and whatnot. And this is the only level of court, except for a couple of cases of original jurisdiction at the Supreme Court, where in the federal system an actual trial of fact is determined. All right, so that's the second step. Now, if you lose, then you're going to appeal, and that leads to the third step. And so you got a couple things here I need you to write. One, you're going to make an arrow going down to a new box. In the new box, you're going to put Circuit Court of Appeals. Now, it's also just called the U.S. Court of Appeals, but it's also known as a circuit court. Okay, so U.S. Court of Appeals or Circuit Court. In the losing side appeals. So I didn't like the decision, you appeal. A couple things about the Court of Appeals or the Circuit Court is that it only has appellate jurisdiction. If you write that off to the side, make sure you write it small because we're going to be adding some things over on the side there. So just be aware of that. So it only has appellate jurisdiction, which means it can review a case. They don't hold trials. They're just checking that the trial was done correctly, that the decision was inconsistent with Supreme Court precedent and the Constitution. So that if the federal district court made some sort of mistake, then they can actually overturn it. They can force them to do a retrial. That's what happened. So the second court is the Court of Appeals. And here's the thing: if you lose, you can keep going. Flip over to the back side of your sheet, make a triangle, and have it have three sections. So you pay two lines, there's three sections. And I just want to give you an idea of how the federal judiciary system looks like. So at the bottom, write U.S. District Court and write 94 districts. And I want you to add 700 judges. Okay, so at the bottom again, you're going to have three sections of the triangle. The bottom section is going to say U.S. District Court, 94 districts, 700 plus judges. So, by the way, all of these are appointed by the president. All of them are confirmed by the Senate. And at the district court level, remember, this is an inferior court created by Congress. Congress has the power to create more of them, make fewer of them, whatever. Okay, Congress has that power, pass a law signed by the president, just like everything else. At the second level, we have the U.S. Court of Appeals. Remember, also called circuit courts. And there are 13. So I want you to add underneath that. So put Court of Appeals nice and big, bold, Court of Appeals. Then write 13 circuits. And then put about 200 judges. Okay, 200 judges. Around. I mean, it's a little less than that probably, but so we have 700 at the district court judge level. Remember, 200 at the Court of Appeals. Court of Appeals, again, appointed by the president. And these are really important positions because if you're at the Court of Appeals, you have a much higher likelihood of being appointed to the Supreme Court. Almost all the Supreme Court justices in the last 100 years, many of them were Court of Appeals justices first. All right, so you got that. And then at the top level, go ahead and write U.S. Supreme Court. And of course, there's only one court. But I do want you to add this: 9 justices. That's it. 9 justices. Now, just a FYI, we'll come back and talk about the size of the Supreme Court in a minute, but Congress has the power to change the size of the Supreme Court. All right, if you need time, pause. I'm moving on. All right, let's talk about the Supreme Court size. There we go. The court has changed over time. The U.S. Constitution gives Congress the power to decide what the size of the Supreme Court is, and you can look over here on the left. In 1789, initially it was 6, and then it went to 7, and then it went to 9, and then it went to 10, and then it went back down to 7 because the Congress didn't want Andrew Johnson, who was very against civil rights for black people who were newly freed slaves. So they like reduced it to 7, so that way he couldn't appoint new justices for some judges that were about ready to leave. And then they increased it back to 9 when Ulysses S. Grant became president. And he was a Republican, and he was very pro civil rights for our newly freed African Americans, and so they increased it back to 9. And it's been 9 ever since. It's been 9 ever since. Could Congress change it again? Sure, they could change it again. That's been a rather controversial topic. In fact, if you look at the cartoon above, it shows Franklin Delano Roosevelt with his court packing plan. The U.S. Supreme Court had ruled against some of his New Deal in regulations and programs. And so he said, you know what I'm going to do? I'm going to add 5 justices to the court. We're going to increase it. We're going to pack the court. We're going to add 5 justices. They'll all be my appointees. They'll rule the way I want. And then that way I win. And this was very unpopular in Congress and failed. However, there's a very famous moment where the Supreme Court, after being threatened with packing the court, started suddenly ruling in FDR's way. And it's called the switch in time that saved 9. It's kind of a funny phrase. So they all of a sudden switched and started ruling in favor of FDR when he threatened them with court packing. So it's really considered very political to court pack. And so it's been a fairly unpopular idea. Although recently, Democrats have talked about court packing as a way to overcome the fact that Donald Trump, when he was president, got the ability to appoint 3 Supreme Court justices. So therefore, if they could, add 4 or 5, then the Democrats or liberals in the court would have the majority again. I don't think that's probably going to happen, but again, it's rather political, blatant politics to suggest such an act at this point in history. Okay, let's keep going. So we started we had a problem. We had some violation of federal law. We went to federal district court. We held a trial. We appealed to the circuit court or court of appeals. And then now the losing side appeals again. But here's the trick. You don't just get to go to the Supreme Court. The Supreme Court only hears cases that it wants to hear. So the Supreme Court must grant what's called a writ of certiorari. A writ of certiorari. At this point, you should have an index card on writ of certiorari. A writ of certiorari simply means you have the right to come here and be heard. 4 justices must say yes out of 9. 4 justices out of 9 must say yes to a court case for it to be heard. So that's what is the next step. If it's granted, then the Supreme Court hears the case. If it's not, which the vast majority are not heard, then it won't. The Supreme Court hears around 90 cases a year, sometimes less than that. And there are 9,000 to 10,000 cases appealed every year to the Supreme Court. So the Supreme Court doesn't have the possibility of hearing all the cases, so they get to choose when they hear it. By the way, that was a law passed by Congress that allows the court to do that. All right, now there's a couple other special ways to get to the Supreme Court other than just through the federal court system, through the district, then appeals, then the Supreme Court. Just a 3-step process, as we outline on the back of your sheet of paper. There's another way, too. And that is go on the left side of your page here and go ahead and put another way, and it's called through the state Supreme Court. So a state Supreme Court, any of the 50 states, appeals a case, they rule on a case, and the ruling side can appeal to the Supreme Court. Now, it's probably almost 100% of the time, it's only going to be granted a writ of certiorari if the state Supreme Court case actually has to do with a federal issue, a violation of the Bill of Rights, something like that. If it is a reserved power to the state, say like election rules, unless the side that appeals can prove that it also violates some sort of federal law, then the Supreme Court's not going to deal with it. They're going to be like, sorry, that's a state Supreme Court issue, and it's a state reserved power. We're not dealing with it. So anyway, just know that it has to be something that violates, also overlaps with a federal issue. Okay, so state Supreme Court. Matter of fact, we're going to be dealing with in Unit 3 coming up quite a few court cases, and they deal with the Bill of Rights, and several of them come right from state Supreme Courts. So that's kind of cool. All right, there's one other way. Let me move myself over here. There's one other way that a case can make it to the Supreme Court, and that is through original jurisdiction. All right, so go to the right-hand side. If you have the sheet of paper in class, you can write original jurisdiction. I can show you right here. And then the arrows going down, you can write a case involving a state versus state, and then a case involving ambassadors. You don't have much room there on the paper, but you should be able to do it. Those of you who are doing this from home and are kind of making your own sheet, just go ahead on the right and write original jurisdiction, and then have some arrows flowing from two types of cases that are original jurisdiction, which is a case versus state versus state, and a case involving an ambassador. Those are the only other two ways that a case can make it to the Supreme Court. Remember, if it's original jurisdiction, that means the Supreme Court actually hears it first, and that means they actually could hold a trial. This hasn't happened in many, many, many years. In fact, if an original jurisdiction case makes it to the Supreme Court, they can actually farm it out to an appeals court or a group of judges from a couple different appeals court and let them hear it first before, and then they just hear it on appellate. They don't really want to fool with that stuff anymore. Anyway, all right, so that's it. Study this. Study the backside where you get your structure. Start at the district court, then go to the appeals court, then go to the Supreme Court. You need a writ of certiorari, and then the number of judges and courts. It's kind of good to know those things too. That will be in the quiz. All right, awesome. Thank you guys. Great job, and make sure you do the quiz.